Good afternoon and welcome to How Do You Deposition? I'm Lori Cripp Martin, a certified family law specialist and the former vice chair of the BHBA's litigation section. I'm delighted to introduce our speaker, Evan Walker. Evan is a San Diego plaintiff attorney and founder of the law office of Evan Walker, where he represents individuals in serious personal injury and major property damage cases. Before founding his firm in 2015, Evans spent years defending insurance companies in complex litigation, giving him a first-hand insight into how insurers evaluate, delay, and deny claims, knowledge that he now applies on behalf of policyholders and injury victims. Evan is a regular legal analyst on local news, a frequent CLE speaker, and is a contributor to the continuing education of the bar. Evan is also under contract with James Publishing for a forthcoming book on insurance settlements. He serves on the board of directors of Consumer Attorneys of San Diego, one of California's largest plaintiff side lawyer organizations. And now let's get started.
All right, thanks so much, Lauren. I apologize to the group. I didn't realize my introduction. She did a great job. Was so long. Enough about me. Let's get started on the materials here because I think we have an hour, and I want to get through this with you guys. So, like Laurie said, screen. How do you depo? So, what is this about? This is about depositions. Before we started, I'd ask the company here kind of what is a makeup of the participants, and I was told it's a mix. So I hope that the talk is going to be beneficial for people that have never taken a deposition or that have taken 500 depositions. It's intended to be kind of an overall 30,000 foot view, but also a refresher course for people that just frankly haven't done it. And I hope that for some people that have done it, that there'll be some tips and tricks, or maybe at least some things you never thought of. Because as if you guys know, the practice of law is more of an art than a science. So with that, let's get started. Here is where we're going today for the next hour. What is a deposition? We'll talk about, what is its legal definition? Where does it come from? Let's talk about the process. What can you ask? That's an interesting kind of topic we'll get into, and I think you may be surprised. Section 3 is how and when to ask it. 4, what do you do when the deponent, the person that's being deposed, does not want to answer, or more specifically, when their attorney tells them not to answer? What do you do in that situation? Because that's going to come up. Your secret weapons, which I'll tell you right now, are going to be the court reporter, the girl or guy they're typing up the transcript, and the written transcript. And then we'll conclude with building your deposition practice, how to, what are the key takeaways in this talk and how to use this information going forward. And that's always the goal in doing these types of things. It's not this, legal edification. It's more, how can I use this in my practice? And that's how I come working through these CLEs and attending them myself as a practitioner and on my own. It's what can I learn today and put it in my practice. And hopefully that's what we'll be getting through today. What is a deposition? So a deposition is a sworn out-of-court testimony given by a witness. And we just said that witness is what's called the deponent. The key characteristics of a deposition are that it's, we just said that, but it's deposition under oath. So, distinguish that with your someone gives testimony either in open court or in a conversation, and it's not sworn testimony. And so that's not what we're talking about here. But it's a little bit more formal than that, because you could actually have a private investigator call a witness, and the private investigator will record the witness and say, hey, do I have your permission to record this? And then he'll transcribe it. It's transcribed under oath. But that's not a deposition. Why not? The difference is going to be that you need it to be recorded by a certified reporter. And if you guys have questions, I think I should have an opportunity to, it should pop up. But if not, I think they'll let me know. So that's what a deposition is. Testimony given under oath and recorded by a certified reporter. A quick side note. I know that there is a trend of, as there is with everything, with AI, getting into the deposition space. And there's been some discussion of depositions where there's not a certified reporter or there's use of an AI. Now, I don't know how that's going to play out. I don't, frankly, even if both sides stipulate to it, I don't even know if that's permissible under the Code of Civil Procedure. I just bring that up to say I've never done it. I don't know anybody that's done it, but I've heard of attorneys doing it. So that's something to keep an eye out for. But as it stands today, March 11th, 2026, a deposition under California law is testimony given under oath, which is recorded by a certified reporter. The legal authority for that, it's here, and I believe all this is in your handwritten materials. It's a CCP. I'm pretty sure that section cited is part of the Civil Discovery Act. I would be shocked if it was not. Some important provisions there. CCP 2025.010, any party may take the oral deposition of any person. Another kind of quick point. Oftentimes attorneys will talk about discovery or discovery. There's kind of two parts of discovery. You have the written discovery and then you have the oral discovery. And the oral discovery is talking about subpoenas. And actually that term also refers to subpoenas sent to third parties, even if they're just requests for documents. That's considered a deposition under the CCP, even though it's not an oral deposition. Any party, that means parties and non-parties. And that's important to keep in mind because we'll get to this later on. Depending on who the deponent is, the process you have to follow for the deposition is going to be different. Any person also means individuals, organizations. We'll talk about that later. Government agencies. The latter two, the organizations and the government agencies, are going to be the procedure is going to be known as a PMQ, a person most qualified. I don't know if we have a slide here. So if I don't think I do. I may. So at the sake of repeating myself, I'll say real quickly, the difference is when you're taking a PMQ deposition, whether that's of a party or of a non-party, leaving aside the different procedures, what you're doing is the PMQ stands for person most qualified. You're asking the deponent to put forward someone who is going to testify on the subjects you want them to testify to, as opposed to a natural person. They don't have to do that. I think a question popped up and I don't know where it went. So hopefully it pops up again. Okay, the deposition process. Before the deposition, what do you do? So, here's a question, I think. Let me just pull this up here. What is the process procedure for taking depositions out of what is a process procedure for taking depositions of those out of California International? Great question. We don't have a slide on that. Here's my understanding is that with your when you want to take the deposition of a deponent out of state, I am pretty certain, I don't know if I've done this or if I have done it, it was a long time ago. There is a procedure under the CCP that allows you to do that. And my recollection is it comes down to having a court issued subpoena here and then having it enforced in another state. And I know other states have a similar procedure called letters rogatory. So the short answer is I'm almost certain that there's a CCP provision that talks about how to enforce an out-of-state or how to enforce a subpoena to depose someone out of state. Internationally, I know that's done through the Hague Convention. How you do that, I'm not quite sure, but I know that that is the procedure for deposing parties or non-parties. Actually, probably wouldn't be a party out of the United States. So before the deposition, what's the process? If you're deposing a party, okay, so, plaintiff, defendant, cross plaintiff, whatever. If they're a party to the actual lawsuit that you are involved in, your counsel of record in, you serve a notice of deposition to the opposing party. So if the plaintiff, let's say I'm representing a car crash victim and I want to depose the driver. We filed suit, the driver is represented. So I'm going to serve a notice of deposition to the driver's insurance defense counsel. And this is all in the code. You need 10 days notice. So you just can't spring the notice of deposition and say, okay, it's May 11th. I want the deposition for May 13th. There's a statutory period that you have to abide by. If you don't, it's improper. The other side has to object, however, but it's still improper. That deadline is extended under, I think it's CCP 1005. If you serve it by, email, which all of us basically do now, personally served or fax or whatever. So you're going to have extensions depending on when you serve it. Subpoena, I see the questions. Let me finish this and I'll see if we can pull those questions up. Subpoena, this is a non-party. We talked about this before. So let's go back to the car crash example. And let's say that I want to depose a third-party witness to the crash. And so once I get that witness's information from the police report, then I have to prepare and send. I don't need court involvement, unlike what I think is the case for deposition for a subpoena outside of California. I just sign off on a subpoena, and then I'm going to have that personally served on the non-parties. That's the difference between the party. You don't have to have the party personally served. You could have the attorney personally served, but the service is always done through the party's attorney. If a non-party is involved, you have to personally serve them. Let me pull up these questions. I'm a damages expert in federal cases. All right, let me just, let me read this real quickly and see if I can answer this. Okay, let me read the shorter questions first. If a party being deposed requires an interpreter, who has to provide and pay for the interpreter? Great question. Let me ask that. Usually what happens is when you send the deposition notice, and I don't think I sent a sample depo notice. If any of you guys want one, email me my contact information here. I'm happy to send it to you. I don't think I did with the materials. But what you'll see in a deposition notice, it says, hey, if you require the use of an interpreter, let us know within, 5 days or whatever. And so that comes up occasionally. And so if that happens, as far as the cost goes, let's say I want to go back to the example. Let's say I want to depose the defendant driver. The defendant driver only speaks Spanish. And the attorney, I put in my depo notice, let me know if an interpreter is required. The defendant's attorney calls me and says, hey, Evan, my guy only speaks Spanish. Okay, all right, perfect. So I have to hire and organize and have an interpreter go there, right, for the deposition. And then because I'm paying for the deposition, I'm also going to be paying for the interpreter's time as well. Now, not to get too much in the weeds, but I want to give a succinct answer. If the defendant driver's attorney says, well, he wants to get a copy of the transcript, I think he may also have to pay, at least in part, for the interpreter. But I know if it's just me and I'm taking the depo, I'm going to have to pay for the interpreter's time. And was it 18 months ago, 2 years ago, I was involved in a case, and we had a ton of people that only spoke Haitian Creole. So we had just a ton. It was only like 1 or 2 people in California that actually spoke it. So it was pretty wild. Sometimes you get in situations like that. And this poor guy, he was like, in every deposition because all these people they only spoke Haitian Creole. Okay, is there a limit of questions you can ask in a dep or any question that cannot be asked? Great question. We will get to that later on. Another question, you need to get the California subpoena domesticated. Okay, great. So here you are. It looks like someone from the audience answered the question that we talked about earlier about doing the out-of-state subpoena. What she says is you got to get domesticated from the clerk, which I think is what I was talking about as far as getting the court involvement here. And then exactly where the state where the opponent resides need to issue a subpoena. So I think we more or less covered that. She had dropped the line of a company that apparently does that. Okay, real quickly, let's see, someone here has a question about expert fees. Okay, I want to get back to this. I don't have time to read that entirety real quickly, and I don't think we get into this because honestly, it's a whole other topic. But when you're getting to experts, Always the most expensive part of litigation. But whether you're planning for defense, but once you get into that, there are very specific rules that apply and even minutely apply to experts and billing time and who is responsible for that. So I would say for the questioner, just so we can get back here, you have to look at the CCP in that area because that answer is there about who pays for what, including prep time, travel time, etc. The prep time usually is for, my recollection is the non-noticing party. But let's go back to this. Before the deposition, we talked about sending a notice. We talked about sending a subpoena. It depends on who the deponent is. Prepare. So this is just a general, like I said, 30,000-foot view on how to handle this. You want to outline your topics, review documents, review the police report, review the medical records, photos, discovery, whatever, what you have in your file that you think is going to be helpful or hurtful even, prepare that. Plan your question sequence. And I say this as again, call it from a practitioner's perspective. Oftentimes, I think that attorneys have a plan or maybe somewhat of a plan, but more often than not, it doesn't seem to be like that much of a plan. And so my recommendation would be preparation is key. It's absolutely key. One reason that it's key is that taking depositions is pretty expensive. I mean, look, if you're not a plaintiff, if you're not a solo attorney and this isn't your department, it's not really that big of an issue for you. But even if you don't, look at the bill sometimes. I mean, if you just take a standard deposition, it's $2,000, right? So, and it's based on page length, which itself is based on the number of questions you ask. So if you're not prepared and you go in there, not only are you kind of wasting everybody's time, but you could just be asking all kind of questions that aren't going to really help your case at all, and you're going to have to pay for that. During and after the deposition. So during the deposition, we talked about us questioning under oath. That's exactly what you're doing. If you're the noticing attorney, you're going to be questioning the the deponent who has to answer the questions under oath. They swear them in before they are deposed. Opposing counsel, assuming that the other side is represented, almost always they are. But every now and then, like I said, you'll get like a third party witness that doesn't have an attorney present. He or she are there to make objections to your questions, and we'll get into that later on how to handle that and what the objections are. The transcript. So the court reporter is there as well. She is producing the written transcript. If you've never taken or attended a deposition before, it's going to be at least 4 parties. It's going to be the noticing attorney, the deponent. The deponent is going to have an attorney, and then the court reporter. So at least 4. And the court reporter is going to sit there silently, and he or she are going to be typing everything up as the questions and objections are being asked. Using the deposition, actually, I should say using the deposition transcript, because the deposition will be condensed into a transcript. You can use it for impeachment at trial, summary judgment motions, or as substantive evidence if the witness is unavailable. And so that can come up really in trial. I don't think there may be a slide or some materials about that. If we have time, we can get into that, because there's a whole separate process you have to follow if you want to do that. But the cool thing is, if you depose someone and they're unavailable, and I put that in quotation marks because unavailable has a very specific term or definition. It doesn't just mean like, hey, the guy's going to go to the dentist on Tuesday. I mean, it's very, very specific on what it means. But if that happens, then you can read that person's deposition transcript into evidence, and it comes in as substantive evidence, meaning it comes in as if that person said that exact thing while sitting in the witness chair. So that's a really cool thing to know, and arguably that's one of the reasons why you want to take certain depositions. Okay, what can you ask? And I think this is one of the previous questions we had. Scope of questions under the CCP, Code of Civil Procedure. So again, I like to take a step back and consider what we're doing here. So what's the purpose? Why are you taking this person's deposition? Well, one of the questions you should look at, or one of the purposes you should look at, is evidence gathering. You want to discover what does a witness know or doesn't know, and then that should shape your litigation strategy, whether you're plaintiff or defense. So sometimes you just go to depose someone because you're not quite sure what they do or don't know. And so this really is like a discovery tool. You just simply just don't know this information. That's why you have to go depose this person. And so that's a good percentage of depositions that are taken, or even the types of questions that are asked during depositions. Another purpose is witness assessment. And by the term witness, we don't just mean like a third party witness. It just means, I mean, it could be a party, right? But that's how the term is used. So you want to evaluate their reliability, their demeanor, their credibility. You know, how do they come across as a witness? I remember, I mean, way back when I did defense work, that was one of the pieces of information we had to give the adjuster during our monthly reports is, well, how did the witness come across? Was the plaintiff likable? Was the plaintiff credible? And so we still do this on, we do it on the plaintiff side. You know, how did the defendant come across? You know, is he credible? How does the defendant's witness come across? Or expert? So that's another purpose of what you're doing when you're taking depositions. Thirdly, you want to lock in the testimony. So this could be crucial for your case. You want to create a record that could be used for impeachment or as evidence. Let's talk about evidence first. And we talked about this in a previous slide. Under certain circumstances, the deposition can come in as substantive evidence. But let's talk about the deposition of a party. So what you can do, whether it's a plaintiff or whether you're on the plaintiff or defense side, if you take the deposition of the other side and they say something during the deposition that is contradicted later, let's see, by their testimony at trial, if you're prepared, you can then at trial come up and impeach that witness. And that can be powerful. It depends. I've seen it kind of fall flat. I've seen it kind of work. So it depends, but that's something that you can do. But the takeaway is you want to lock in the witness's testimony because remember, a deposition is sworn testimony under oath. It's being transcribed into a record. And so the record, the witness, the deponent is saying, this is the gospel truth. And so you're locking it in with the deposition. And so now you know what the witness has to say about whatever the issue is. The framework for this, as far as what you can ask, and this has a little bit of nuance, which we'll get to in a minute, is CCP 2017-010. You can discover anything that isn't privileged and is relevant to the subject matter and is either admissible evidence or reasonably calculated to lead to admissible evidence. That's called like the overall rule, right? That's the umbrella rule. There's a little bit of nuance and exceptions kind of beneath it, but that's the overall framework when you want to think about what can I ask? Well, if you get pushed back to some of your questions, if you can articulate that what you're getting into isn't privileged, or even if it is, they didn't raise a privilege objection, and it's relevant to the subject matter, and either the evidence you expect to get with the questions is admissible or it's going to lead to admissible evidence, which is really broad. It's a really broad standard. Then you should be allowed to ask it. That would be my position. I think that's backed up by what we see here. Okay, what can you ask? Yeah, like I said, that's the umbrella rule. Any non-privileged matter that is relevant to the subject matter and is admissible evidence or reasonably likely to lead to admissible evidence. So that kind of second part, like I said, that's just it's so broad. I think it's kind of superfluous. It doesn't really matter. So really the question is it is non-privileged matter that is relevant to the subject matter? And I would say even that is debatable because even if it's a privileged matter, which we'll get to in a minute, if the other side doesn't raise a privileged objection and the deponent answers it, it's still good, arguably. So really, to me, the analysis is the question you're asking relevant to the subject matter? So for example, let's go back to the car crash example. And let's say I'm asking about the defendant's, um, let me think here. What's his favorite superhero movie? I mean, what does that have to do with anything? Am I just trying to like be like a cool guy with the witness to get him to like me? I mean, to me, something like that is like it's got no relevance whatsoever to the subject matter. So that's one way to think about it. Normally, you really won't come across that stuff, but that's the standard. So what does that mean in practice? Well, you can ask about backgrounds of the deponent. You can ask about the qualifications. That's really going to come in when you're deposing an expert. You want to know what qualifies this person as an expert. What is their training, education, experience? So you don't really see that a lot with percipients witnesses, which is anyone that's not an expert. But it could happen. Facts of the incident, right? Especially with you're in litigation, you're dealing with liability. You want to know what exactly happened. What does the deponent think happened? Documents. We talked earlier about in your preparation, you want to gather up the documents depending on the deponent. It depends on what documents you're gathering and preparing. Like I said, it could be medical records, police report, animal control report, photographs, estimates, repairs, anything like that. And so this witness, you may want to question them about it. You may want to get them to clarify it, but you can ask them about that. Communications. So I put this here because I think this is important to know because I've actually like way back when I think I debated this in a deposition. I was dead wrong, and the defense attorney called me out. Since I don't really push back on it, but you are allowed to know about the time, date, and location of attorney-client communications. So, if the deposing attorney wants to ask the defendant or the plaintiff, did they meet their attorney on, May 11th at 2:30 at, front of the courthouse? Under that case, which is cited, it may be any materials or not, but you got the pin site there. You can get into that. Of course, you can't get into what was said, any verbal or nonverbal communication. That's a clear no-no. But as far as the date, the time, and the location, that is discoverable. And again, I just put that pin site there because I know that gets fought over in depositions sometimes. And I think there's a pretty clear answer is that as long as it's date, time, location, it's allowed. You cannot harass the deponent. We see this, or at least I do. We see this all the time. Objections come up, harassing, leaving aside that's not a real objection. But you don't want to get in there and just kind of be a jerk, basically. Now, I understand, depending on the case and the opponent and the dynamics, things may need to be done sometimes. I understand and I see both sides of that. But, we're not here to be bullies and to beat up witnesses and just kind of harass them and get into things, that are embarrassing or wherever, again, if they've got nothing to do with the case. Because we're given an immense amount of power as attorneys. And, as we all know, with immense power comes immense responsibility, right? And so we're not going to go in there and just, take advantage. We're not supposed to take advantage of that. So I think that's kind of what this is getting as far as not harassing the deponent. You can ask contention questions. This is the famous case I'm sure most of you guys know about Rifkin. That's allowed. I'm sorry. I think that's wrong. Yeah, I'm sorry. You cannot ask. Thank you. I should bring my old slides. You cannot ask contention questions. You can send propound contention interrogatories. Do you contend another party was responsible for the incident? Do you contend you were not injured in the incident? Whatever. That's fine. But when it comes to depositions and deposition questions, you cannot ask. Well, you can ask, but it's improper. It's improper to ask contention questions. So that's something that you cannot do. In the Rifkin case, if you haven't read it, it's worth taking a look at. How and when to ask, types of questions, strategies, and sequencing. So this is where we kind of get into the strategy and the thought process of the types of questions to ask. And what this is it's not that you say, okay, I'm only going to use open-ended during this entire depositions. This is like a toolkit, right? Depending on who you're deposing, what you're trying to do, and where you are in the deposition, these are the three types of questions you would want to be asking the deponents. Open-ended questions. And this is what we talked about before in terms of discovery. You want to learn what the deponent knows or what the deponent doesn't know about whatever the issue is. And so these types of open-ended questions, they encourage detailed responses. They're not open shut, yes or no, black and white. It's these questions are designed to allow the witness to talk and to reveal information you didn't know to ask about. So it's almost, it's when you get, written discovery, it says fishing expedition. Okay. I mean, you could say this is a fishing expedition, but, I would push back and say, look, oftentimes you have to ask these open-ended questions. The pushback you can get sometimes in doing that is the other side will say objection, calls for a narrative. Now, my position would be, and I think this is legit, is that's a trial objection. And I don't think that's a proper objection for a deposition. And assuming that's correct, you are you're well advised to do open-ended questions if they're legit. So, an example, what were you doing the minutes before the incident? That's fine. Now, if the deponent starts to say, starts to get carried away, and starts talking about you can gently kind of bring them back or, kind of clarify and say, well, I'm not really interested in that. I'm more interested kind of in this and help direct it and help control it. But that's an example of an open-ended question. Another one that you'll hear often, or at least you will ask often, if you're a defense attorney, and you're dealing with an injured plaintiff, how has this life affected, how has this incident affected your life? And to give a little bit of the plaintiff's secrets away, I mean, that's a good question. I think that's why defendants ask it. And if the plaintiff is unprepared for that question, that could really hurt the case. So, I mean, let's think about this for a minute. If an astute defense attorney asks a severely injured plaintiff, well, tell me how this incident has affected your life. And the plaintiff, and I've seen both sides of this, and the plaintiff, they can't really articulate a response, right? And the reason is oftentimes they're scared, right? I mean, being in a deposition, it's for most people, especially for people who have never done this before, which are, at least for the plaintiff side, or most plaintiffs, it's terrifying. It's nerve-wracking, right? And so it's almost like a deer in the headlights. And a lot of people, at least I know a lot of people that we represent, aren't familiar with the legal system and with lawyers and things. And so it's a very nerve-wracking kind of time for them. And when they get a question like this, again, assuming they're not prepared for it, they don't quite know how to answer it. And so sometimes you can see the plaintiff say, well, I don't know. I don't really think it has. And so if you're a defense attorney, that's a great response for you, right? I'm just calling it for what it is. That's a good response for you. And that's why I think the question is asked. And I bring this up, I know it's in the context of open-ended questions, but sometimes you can ask an open-ended question like that and not get, and it actually turns into kind of like a closed question. You shut it down. You've locked in that testimony. It's done, right? But, other times, maybe the plaintiff has been, has thought about this question and is prepared for it. And the plaintiff says, well, what areas do you want me to talk about? You want me to talk about my marital life? You want to talk about my relationship with my children, my grandchildren, my job, my commuting, how I exercise, the type of hobbies I can no longer do, right? And so that would be a response to an open-ended question. Closed questions or closed-ended questions. These are admissions, black or white, open shut book, it's done. Elicit yes or no answers. This is helpful for the party taking the deposition because you're locking down specific facts. You're locking in testimony for trial. Remember, this is sworn testimony under oath being transcribed. So whatever the response is, this person is arguably tied to it. Example, were you at the location on March 5th? That's a yes or no question. right? Now, I know when you guys, those of you that have deposed experts, you can realize how slippery they can be when it comes to close questions. The expert, may say, well, what do you mean the location? And well, I'm not sure about March 5th. So for the most part, people are pretty straightforward when it comes to close questions. But sometimes, you do this and you'll come across someone with experience, we could say, and they know the danger of responding to a closed question. But that's something to have in your toolkit too, because they're necessary because they lock down testimony. Another example, did you receive the April 3rd email from Mr. Jones? That's a yes or no question. And you'll see this too sometimes. Let's say you have an important contract case, it's a business dispute, and receipt of the April 3rd email is crucial for your case. Okay. And you need the other side to admit that they received it. And you slide the copy of the email across the table and say, now, sir, did you receive this email from Mr. Jones? Well, I mean, I think he is going to have to say yes or look foolish because it's right in front of him. And if he wavers kind of back and forth, that's when you want to take a step back and just kind of go at it differently, but keep pressing, respectfully, professionally, but don't give up just because you had some resistance and get the response. Why? Because once you lock down that key admission, that's extremely helpful for your case. The other way to think, the other kind of example in your toolkit is a leading question. This is about control. Now, you're suggesting the answer in the question. Now, this is normally not permitted, right? There's a valid objection that says leading. You're leading the witness. You can't do that in depositions for the most part. However, if you can do it under evidence code 776. Okay? So you do this at trial and a deposition. If you're deposing, you can ask leading questions where you're suggesting the answer. And there's a whole kind of strategy and a whole nother course could be taught on this. But an example of leading question is, you were driving 60 miles per hour. True. I don't like the true part, but some people do that. But basically, you're asking a question. You're saying something that's formed like a question, but it's more a declaratory sentence, right? That's the point that you're making. You don't really care about the answer. You care about the question, but that's kind of trial talk. You knew the contract was unsigned. Okay, so those are 3 types of questions. Strategy. Again, let's just revisit this because it's so crucial. Know your purpose. Purpose is to get information. We talked about this. We'll talk about it again. Discovery depositions. Learn what they know. Learn what they do not know. Get admissions. Oh, let me say something. So you could pivot. You could say, let's say you're deposing the defendant and you wanna get some information about, let's say, let's go back to the contract example. And, let's say you don't know whether or not the defendant actually read the contract. And so you could say, hey, have you seen this contract before? Yes, I have. Or have you read it? And this is an open-ended question, although it sounds like a closed, simply because you just don't know the answer. Have you read this thing? No, I haven't read it. So at that point, you want to lock in the testimony and just pivot and say, sir, are you telling me that you've never read this contract? No, I have not. Now you've locked it down. Get admissions, what we just talked about, pin down facts that are favorable for your case. I mean, this is what both sides are doing. Prevent surprises, very similar to that. You want to lock in testimony so it cannot change at trial. And that is important, especially when it comes to deposing experts. There's a whole objection in a case law, Kinnemer. Kinnemer, when you ask the expert to, one of the kind of, again, this is a whole separate course. We're not going to get too much into it, but when you ask the expert during his deposition, are these all the opinions you're going to give at trial? Nothing new. Yes. Okay, you've locked it down, right? And then if you go to trial and the expert starts giving some new opinion, you object and say, Kinnemore, Your Honor, and the judge should sustain the objection. Assess the witness. We talked about that. You want to evaluate the credibility and demeanor, not just for trial, but also for settlement, right? And this really, I think, comes in for the defense side and the side of the carrier, if the plaintiff comes off as credible, as likable, does a good job with her deposition, she's not making, kind of just mistakes, or she seems flustered, that could make your case more valuable in the eyes of the carrier as one that they, want to settle because there's just a bigger exposure. When they refuse to answer, what do you do? Objections, instruction not to answer, and remedies. I, I think I've seen the most heated litigation really come in depositions, right? And I've seen, I would say, probably the most discovery abuse when it comes to depositions. And I don't know if it's that the attorneys, either they don't know what's allowed, or they don't care, or what. Look, and I've been guilty of it. I'm not throwing stones. I've been guilty of it too. I'm just here saying that I've seen really things just get really unnecessarily heated and become a big mess when it comes to depositions and objections. So it's important, again, just to go through the rules here. So form objections. What are form objections? Ambiguous, argumentative. We'll go through them one by one in a sec, but those are waived if they're not raised at the deposition, and that's according to the CCP. Okay? So why do I say that? Well, because there's a lot of questions that aren't form, right? They don't necessarily need to be asked because you can bring them up later, right? Use at trial or something else. And so the only ones arguably that you would need to raise if they were legit objections are the form objections. And that's going to be ambiguous. Now, why is that important as an objection? Why is that a valid objection? Well, if you ask an ambiguous question, meaning it's unclear what exactly your question is, it could be read in more than one way, then the deponent responds to that question under oath. Remember, it's not clear what the deponent is really responding to because the question's unclear. And so that's a valid objection. I understand it. And so how would you handle that? If you ask a question and the opposing attorney says, objection ambiguous, simply rephrase. And frankly, that attorney's doing you a favor because you don't want to be asking ambiguous questions. Argumentative. Now, I think we talked about this earlier. I was kind of laughing about the harassing. This comes up all the time. Look, to me, I mean, argumentative is very similar to harassing. I mean, some would say there's a fine line. I mean, you want to get in there, you want to get the information, but you don't want to berate or bully or be kind of argumentative. That's not kind of the deponent. I know we all get carried away, but the deponent is not your enemy, right? If there even is one. So that's not what should be going on. Assumes facts not in evidence. Why is this a valid objection? Well, let me say it differently. How would you handle something like this? Really, what the question is, it goes to foundation, and that's why it's a valid objection. I think that's how I understand that objection when I hear it. So if you're asking the opponent something that they really have no foundation, no basis for which to give a response, right? That's what that's getting at. So you want to make sure you can lay that foundation in order to get that information in. Compound, this is very similar to the ambiguous because compound, is disjunctive. You could have more than one response to it. And so if you hear the objection compound, just rephrase it, break your question down. Because again, if the deponent gives an answer, it's unclear what the deponent is really answering. That's a danger. Leading, we talked about the exception 7776 under the evidence code, ask and answered. You know, we hear that a lot. Ask and answered, ask and answered. And so that's why I put this site on there. According to that site, that's not a valid objection. So you need to look at that. Now, this is important. The other kind of box here. These objections are legit and they must be brought up or they're waived. And so this is really, really crucial if they apply and someone gets into this and you as a defendant attorney don't raise this objection. You've waived it. You can't go back and say, oops, me culpa, it's done. So any privilege, you have to raise it or it's waived. So the attorney-client privilege, remember we talked about before that the location, the time, all that stuff, that's discoverable. So if the deposing attorney says, hey, did you meet with your attorney on, May 11th at 12 a.m.? Yes, I did. What did you talk about? And then if you, as a defendant attorney, don't object and say objection, attorney-client privilege, and your client, the deponent, says, oh, it's funny you should ask. We talked about settling the case for $100,000 or whatever. That information's done, right? You could probably clean it up if you really had to, but that just shows the importance of raising privilege objections. Work product privilege, you need to raise that. Trade secret, these are all common privileges. Spousal privilege, remember under the evidence code, those are actually two specific types of marital or spousal privileges. You have the privilege, which is, I forget the site, but they're both right next to one another in the evidence code. Confidential marital communications. Okay, so whatever spouses say to one another, it's presumed confidential, okay, in the course of the marriage. And then not to be called as a witness against your spouse. Arguably, people think about this, I think, in terms of trial, but arguably, if you call, let's say the woman, you represent the woman, and she's injured in an incident, and the defense then sends a third-party subpoena to the husband and wants to depose the husband. Arguably, the defense is now forcing the husband to testify against the wife. So the way to do that would be to attack the subpoena and raise it as, raise a spousal privilege, specifically not to be called as a witness against your spouse. What do you do when the witness won't answer? Of course, this comes up. So it's important to kind of go over the ground rules here. The witness must answer despite objections, right? Unless they're instructed to, not by counsel. So let's talk about that. Because like I said, if you've taken more than 2 depositions, you're going to come across this. So what do you do? What do you do? Well, ignore the objection. Most objections at the deposition are improper. We talked about that. Or they're preserved anyway, right? They're not waived. It's really the privileged one. The privileged objections are the ones that are waived. You direct the witness to answer, right? So let's just say like you're asking the deponent a question and you get you get an objection, right? And because this happens, and then the deponent kind of looks at the attorney, her attorney. What am I supposed to do here? And you as an opposing attorney say, ma'am, you need to answer the question, right? And you press on. One thing to note is pushback against speaking objections. I've seen it's not that bad. I'm just speaking anecdotally from my own experience. I'm sure you guys have different experiences, but occasionally it happens. In a speaking objection, you're going to see it where it says, let's just say you ask a question, and let's just say the defendant attorney says, objection, my client's not going to answer that question about a medical treatment. You have all of her medical bills. You understand that the medical treatment was necessary, was related to the incident, and my client's not, blah, 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 blah. Basically, the attorney is testifying, right? That's completely improper. There's no way that flies under the code. Getting back to what you do. So what do you do? Well, I guess on the speaking objection, you just want to tell the attorney, because you're on the record, please, avoid speaking objections. That's improper. I'm going to ask my question, and you're not here to testify. You're not under oath. Let's say you ask a question, you get an objection, and the objection has merit. So what do you do there? Merit, like we talked about, it's ambiguous, it's compound. Simply rephrase it. We talked about that. It shows good faith, it gets you a cleaner record. I got to go a little bit faster. I think we're almost out of time here. What if the deponents still want to answer the question? So what do you do? Let's just counsel says he instructs the deponent, his client, not to answer. That's only privileged. I mean, that's only proper in terms of privilege, privacy, or court order. You can make an argument that that's proper under Rifkin for contention. That's debatable. It could go either way. But what you do if you ask a question and the defending attorney tells his client not to answer, you suspend the deposition, you file a motion to compel under CCC 2025-480. That's the proper proper process. Your secret weapon, a court reporter, written transcript, build the record. So everything goes to the record. No nodding, no gestures, make verbal responses, spell names, technical terms, addresses. This is huge. And I think all of us do this now, basically, despite the cost, videotape the depositions. I'll give you a brief example. So we were taking a deposition, I don't know, some time ago, and it was my client being deposed, and one of the defense attorneys, he got really heated and animated. I even forgot what the issue was. And he was a kind of big guy. He's kind of big guy. My client was an older, smaller man. And we didn't have it videotaped. And I forget the reason why. I broke our own rule. We didn't have this videotaped. And so the attorney, the defense attorney, he stands up and he's like, he's pretty tall. He's a little bit taller than I am. And he starts shaking his finger like this in my client's face. And I forgot what the specifics were, but it was very, very uncomfortable, right? And very aggressive. And so we called him out on the record and said, Mr. Smith, whatever, please, you're standing up. Please sit down and stop shaking your fist in my client's face, right? And that even got him more angry. And this went on for a couple of minutes, and eventually he stopped, or we took a break or something to calm down. But I bring that up for this example. What you would see on the written transcript, right, is kind of these questions and my client's answer. If I hadn't had, actually detailed on the record what this guy was doing. But even better, if we had videotaped it, I think he probably wouldn't even have done it, right? Because people act differently on videotapes. But it's not just that too. It's not just to kind of marshal each attorney's behavior. It's to see the deponent's reaction, right? How long they take to pause to answer a question, which should be you should answer it pretty immediately, right? What do they do? Are they looking around? Are they looking at their attorney? Are they looking like a deer in the headlights? Get back to the question about the plaintiff, right? Looks like a deer in the headlights when she's asked about how does this injury impact her. So, and we're also wired now to understand things through video and visuals and all these types of things. And so it's crucial. If you can't afford it, I get the cost, I really do. But most of us to videotape the depositions, because it's a whole different game once you can sync the written transcript with the visual impressions of the deponent. Mark your exhibits clearly. These are just practice points. Mark them sequentially. It's easier to follow. It could be hectic then if you just kind of get lost in the weeds. You want to make things easier for yourself, lessen the cognitive load. Ensure you bring copies for all parties. If you're doing the depo in person, keep a running log. This is just going to help you. Control the room. Look, you're going to, you do this, say one or two, and you'll see what I'm getting at here. They'll be back and forth, right? There'll be questions, objections. People are, feathers are getting ruffled, It's helpful when you get into this to kind of take a step back and just ask the reporter to read the question back and the answer, because she's kind of typing everything down. And so sometimes that's helpful instead of getting into some big fight about what was said and blah, blah, blah. Just go back because there's this tentative record being done simultaneously or concurrently. Usual stipulations. I don't see us getting asked that much anymore. There was a famous or infamous SoCal stip. I think it's kind of fallen out of favor. But sometimes you used to be asked, well, you agree to the usual stipulations. And just for like a newer attorney who may be not quite sure what that means and kind of thinks, okay, may say, okay, sure. Well, I wouldn't do that. I mean, you need to ask, well, what does the other side mean by that? That's what I would do, right? I mean, it depends. It depends on what the stipulations are, right? You could stipulate to reserve all objections except to form. Actually, that would be before the deposition. I've done that before. That's helpful. But when someone asks you usual stipulations, you need to ask them, well, what do they mean by that? Using the written transcript at trial, we talked about this. Impeachment, you can confront a witness with prior inconsistent testimony. The deposition, they said the light was green. At trial, they said the light was red. Okay, read the transcript, question and answer. So again, we don't really have time. There's a whole process to do this, but basically you're going to lodge your depo transcripts with the court. And then if the witness says something inconsistent with the deposition, Your Honor, may I read from the deposition transcript? Okay, line and number, and then it's question, answer, question, answer. Again, there's a whole strategy process behind it, but that's basically it. Substantive evidence. We talked about this. Here's the code. I think this is in your materials. If it's not, you need to get this because it's huge. CCP 2025-620, that governs when deposition testimony is admissible as substantive evidence at trial. So it can be used against parties in any measure. It could be used for expert witnesses. It could be used for witnesses that are unavailable. So there's a whole host of ways you can do it. And so if you videotape the depositions, you just go into court, boom, you hit play. And again, the impact is not as impactful, but sometimes you got to do it. That's just like the witnesses testifying. But there's a whole process you have to follow, but that's where you get started on doing that. We talked about this too. Absent witness, if the deponent is unavailable, their testimony may be read into the record as if it was live. After the deposition, you're going to get the transcript, read it, make sure it's correct. Sometimes mistakes happen. I think it's less often now, but you want to make sure it's correct. You can take that and use the transcripts from earlier depositions to prepare for later ones, cross-reference testimony. The point is having the transcript and then using it as a tool to further your litigation strategy. You just don't take it and it's one and done. You put it in a drawer or the cloud or whatever. You never think about it again. You're going to use it to further what you're doing. Motion practice. Depo testimony is the backbone of summary judgments, motions in limine, and trial briefs. All right, I think I got 2 minutes. Okay, I think this is the last part. Building a deposition practice. We'll go real quickly. Ground rules for the witness. Again, whole courses could be taught on this, but 30,000-foot view, if you're sitting to prepare the witness, whether you're planning for defense, I don't think it makes a difference. You tell the truth. This is what you want to tell them. Listen to the full question before answering. If you don't understand, ask the question attorney to rephrase the question. Don't guess. Say you don't know. A lot of times it seems to me that opponents, they want to be helpful, even though it's an adversarial proceeding. And so they kind of just want to give a response. So you got to tell them, look, it's okay if you don't know. I don't know is a valid and legitimate response. Don't talk over the questioner. It gets confusing. It messes up the record. Wait for instructions not to answer if that's given. Remember that example we gave before? If the questioning attorney gets into a section that's privileged and the client just starts to blurt it out, right? The damage is already done. So, you need to instruct the client, if I say, don't answer that until, I tell you something differently. Appearance matters, even so with remote depots, discuss attire, you don't want them showing, I've heard, wasn't my client, but I heard stories of like people like vaping at remote depositions and stuff. Look, you don't want to do that stuff, right? And watch the background too. You don't want something crazy in the background. A 3-session approach that I sometimes use is session 1, you meeting with the client, you want to go over key areas, likely questions, talk about the ground rules so they know. Session 2, practice with sample questions, build confidence, coach on delivery. It's almost like you're doing like kind of test run, because like I said, almost all clients, this is the first time they've ever done anything like this. It's very nerve-wracking. Session 3, role reversal. You can play opposing counsel, pressure test the witness. So the point is to get the witness comfortable with what is this procedure going to be like? What can I expect, right? Just so they're not thrown in there like a deer in the headlights. All right, deposition. I think this is our last slide. Oh, all right, I'm going to just real quickly. Creating a depo checklist. We talked about this. Review the pleadings, discovery, do an outline. Be flexible though. You want to follow the outline, but don't be wedded to it. Review any prior depo transcripts, any exhibits, research the witness. Again, do the background first, open-ended, then narrow, lock it down. We talked about that. Mark and identify exhibits, stay professional. After, review the transcript, update your case strategy, identify any follow-up. Maybe you need to send some more discovery, evaluate for motion practice, and you start looking at the transcripts in the context of trial. Checking your behavior. All right. Look, we know this stuff. Be calm, be professional. Don't get upset. Don't stand up and shake your hand at the witness. Don't make speaking objections. Don't raise your voice. Don't scream. No personal attacks. It's all the stuff we knew in kindergarten. Okay. Develop your skills, read transcripts, watch videos, but nothing replaces the actual act. It's one of these things where it's experience that teaches you. You have to get in there and do it. Know the rules, especially the ones we went over today. Watch experienced litigators take depositions, take CLEs like this one, review your own work, look at your own deposition transcript. Last thing, key takeaways: know your purpose for every question, discover your admissions, court reporter, and transcript, most powerful tools. We talked about why. Most objections are preserved. Don't get scared of them. Preparation and flexibility are not opposites. You need both. Transcript is a permanent record of your professionalism. Boom. I think we're done at 11:30. If you guys have any questions, did I not put oh, here we go. That's my contact information. Feel free to reach out to me, and best of luck in everyone's practice. Thank you, guys.